Hello, everyone. This is John Borkowski, and I'm a partner in the education group of the national law firm of Husch Blackwell and a longtime advocate for public education. On behalf of our education group, the firm, and our partners at the Council of the Great City Schools, it's my pleasure to welcome you back to the Emerging Legal Issues in Urban Education webinar series. We're excited to be continuing to offer this series to our clients around the country and to members of the Council. I'd like to begin by thanking our friends at the Council for their help with this series, particularly General Counsel Mary Lawson, who's joining us today. In addition, I'd like to thank all of you for attending and participating in today's webinar about religious freedom and accommodations for students and employees. I'd also like to remind you that, as always in this series, the discussion during the webinar is intended for general informational purposes only and should not be construed as legal advice. If you need legal advice, please consult privately with us or your regular legal counsel, as the answers to these complicated legal questions always depend on your district's particular circumstances. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit those via the question box. We really encourage you to ask questions throughout the webinar. We'll try to answer them all during the program. If we run out of time or a fuller answer is required, we'll respond afterwards via email. A PDF of the presentation is available in the Program Materials folder. This program has also been approved for continuing legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including the course number, will be emailed to you tomorrow, along with a recording of the entire webcast for watching and sharing within your organization. Toward the end of the program, please be sure to complete our short survey. We really depend on your feedback in planning our programs, and we want to make sure that we're responsive to your needs and present on topics that you find timely and relevant to your work. So that's it for housekeeping items. Let's go ahead and get started with the program. Joining me today, as I said, are Mary Lawson, my colleague Alex Rushing, and my colleague Claire Hawley. Mary Lawson is the General Counsel of the Council of Great City Schools. For 19 years prior to that, she was an Assistant General Counsel in both Broward County Public Schools and Miami-Dade County Public Schools, over 16 years in Miami. Prior to her legal service in school districts, Mary was an attorney at a prominent DC law firm. Mary actually began her career in the classroom, spending 8 years as a secondary school social studies teacher in Pittsburgh, Broward County, and Anne Arundel, Maryland. Alex Rushing is also a former public school teacher. Now she counsels schools all across the country on investigations, litigation, and compliance matters arising from a wide range of civil rights and educational funding issues. Claire Hawley is also an education attorney at Husch Blackwell. After her undergrad years, Claire earned a grant to work with the Illinois Network of Charter Schools and worked with the legal team there. She took that experience to law school and has been with the firm now for a couple of years. Today, she views every legal challenge for her clients in education as a complex puzzle to be solved. So here's our agenda for today. We're going to talk about the legal protection of religious freedom under the First Amendment. We're going to talk then about public employee speech issues and the issues of retaliation. And then we're also going to talk about religious accommodations, accommodations for staff members, and also accommodations for students. And with that, I'm going to turn it over to Alex to get started on the substance of our program. Alex?
Thank you, John. I appreciate it. Let's dive in to the legal principles of religious freedom. So let's start with what laws protect religious liberty. This slide shows an overview of the laws that protect religious liberty: the Constitution through the First Amendment's Free Exercise Clause and Establishment Clause, Title VII, and state law, which we'll only briefly discuss as it varies widely depending on your jurisdiction. We'll start by talking about religious freedom under the Constitution and move on to the next slide. On the screen, you'll see the text of the First Amendment. The First Amendment only restricts the actions of federal, state, and local governments. This includes K-12 public school districts, state colleges and universities, and then private institutions that are governed by their policies and contracts, and in some instances, state law. Here are some general principles of government regulation of speech, including religious speech. The government is rarely allowed to discriminate based on viewpoint. To regulate based on content, the government must satisfy strict scrutiny. Regulation of subject matter is content-based. Regulation of a particular message is viewpoint-based. A law that says, for example, you can't have any political signs in your yard is content-based. But a law that says you can't have any libertarian signs in your yard is viewpoint-based. According to the Supreme Court, viewpoint discrimination is, quote, an egregious form of content discrimination. And that comes to us from the Rosenberger versus Rector and Visitors of the University of Virginia case. In certain settings, which we call forums, the government can limit the subject matters to be discussed by category and can impose reasonable time, place, and manner restrictions. You've probably heard that term used over and over again. How loud is the speech, the time of day, things like that. Traditional public forums are public streets, sidewalks, and parks where individuals have the greatest free speech rights. There is a distinction between content-based and viewpoint-based regulation. While the constitutional standard is the same, strict scrutiny, some types of content-based discrimination may be permissible in a limited public forum or a non-public forum, while viewpoint discrimination in those same limited or non-public forums would not be permissible. A classroom, for example, is considered a limited forum, if not a closed forum. The text of the Establishment Clause, which is discussed on this screen, says in part, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. It's worth noting that the Establishment Clause only applies to public entities, federal, state, government. The Establishment Clause is a limitation on the ability of the government to take certain actions that would favor or advance religion. Until the last couple of years, there was a very elaborate and complicated Supreme Court test, some of you may remember from law school, called the Lemon Test, that helped guide how we thought about when government went too far in involving itself in religion. And without spending too much time on that, we can say that this Lemon Test is no longer the law. The current Supreme Court has essentially eliminated it, viewed it as overly restrictive, I guess, and overly complicated, and is trying to take Establishment Clause case law back to more of a historical analog. So what can we say today? First, the government can't take actions where the sole purpose of the action is to advance religion. The government also can't mandate or coerce participation in religious practice. The government can't pick and choose how it regulates religious groups or show any preference for certain religious denominations. But at the same time, religious entities can benefit from government programs that are generally open to non-religious groups. Excessive entanglement is narrowly focused on church governance and beliefs, meaning we don't want the government dictating how religious organizations function or trying to determine what are or are not permissible religious beliefs. So basically, the Establishment Clause operates as a limitation on the government's ability to advance and involve itself in religion. We'll move on to the next slide talking about the Free Exercise Clause. While the government can't enforce religion on people, it also can't take actions that infringe upon the free exercise of religion, like we talked about on the prior slide. The definitive case on the Free Exercise Clause is Employment Division versus Smith from 1990. In that case, the Supreme Court was faced with this issue. We have lots of laws in this country that are enacted for secular purposes, and yet sometimes that might limit things that a person would do for religious reasons. There are laws, for example, that ban trafficking in eagle feathers, and yet for certain Native American religions, the possession of eagle feathers in religious ceremonies is something that's very important. Or in the Employment Division versus Smith case that I mentioned, you had a question about whether an employee could be punished because they smoked peyote, a prohibited drug, as part of a religious ceremony. The court held in the Smith case that as long as there is a generally applicable religiously neutral law, that law can impose an incidental burden on religion, as long as there's a rational basis between the law's purpose and the means used to effectuate it. So if the government bans drugs because drugs cause negative health effects and are highly addictive, and that has an incidental effect on prohibiting someone from using drugs in a religious ceremony, the Supreme Court in Smith said that's constitutionally permissible. That doesn't violate the free exercise clause. But the government can't pass laws or take actions that specifically target the free exercise of religion. So the difference there would be if we had a law that said no one can use illegal drugs, that is neutral and generally applicable. But a targeting law would say no one can use illegal drugs in a religious ceremony. Those targeting laws are subject to what we called earlier strict scrutiny, which is essentially the court saying, this probably violates a constitutional right. You have to really convince us you have a compelling reason to do this, and you have to have chosen the least restrictive means, the narrowest possible means of satisfying that interest. You have to say so. The reason why you're saying it is so extremely compelling. We also have federal civil rights laws that, as you can see on your slide, called Title VII, that regulates discrimination based on a number of protected statuses, including race, national origin, and religion, among others. Title VII applies to both public and private employers. With regard to religion, Title VII does two things. One, it prohibits what I'll call classic discrimination based on adverse treatment. So you can't refuse to hire someone because they are a given religion. But it also means efforts to reasonably accommodate religious practice, which is a separate construct. And some religious practices involve the verbalization of religious beliefs or religious speech. So employers have an obligation to accommodate religious practice, including religious speech, by employees under certain circumstances because of Title VII. In upcoming slides that Claire will talk about, we'll discuss how this ties into the somewhat tangled ball of legal principles protecting religious liberty. So Title VII prohibits adverse treatment discrimination based on religion, meaning generally speaking, you can't refuse to hire someone. You can't fire someone. You can't demote someone. You can't deny them a raise because they are religious or because they are of a certain religion or because they aren't religious. Where religion is the motivating factor in that adverse treatment, Title VII would be violated. You could come up with an example where the reason why you learned an employee was religious is because they said so. And then if they were demoted by a supervisor who had animus towards their religious beliefs, that would likely be a violation of Title VII. Separate and apart from these constitutional and federal law issues that we've talked about on the prior slides, there are a set of state statutes called Religious Freedom and Restoration Acts. Typically, they're called RFRAs, and not every state has one, but many states do, so we'd be remiss if we didn't cover them, at least on one slide. These are state laws that were enacted as a response to the Supreme Court's decision in Employment Division versus Smith. Some states basically said, hang on, this Smith case is overriding religious liberty, so a lot of states passed these laws that essentially say when our state agencies burden religion, even though the Constitution might not require them to meet strict scrutiny in every case, as a matter of state law, we will require them to demonstrate that they have a compelling reason to target or burden that religious belief or that religious practice, that they're using the least restrictive means. So it's basically a way of imposing strict scrutiny, that higher standard of scrutiny, on any burden of religion, even if it's from a neutrally applicable law or rule. And that applies at the state level if your state happens to be one that has RFRA. If you work at a public school and your state has one of those laws, it essentially adds a heightened level of scrutiny to a public employer's attempts to restrict religious practices. There are also state human rights acts that protect religion, among other protected categories. For example, the Minnesota Human Rights Act prohibits discrimination based on religion in public accommodations, public services, employment, etc., but it also has exemptions for certain religious institutions. State laws often apply to private entities, even where the Constitution does not, so be mindful of that. State laws are complicated and vary based on jurisdiction, like we talked about at the front of this hour. So we won't dive into them too much further, but it's important to note that they exist and often provide another layer of protection from religious discrimination. So with that, I will turn it over to my colleague, Claire, who will talk about religious accommodations for employees. Claire?
Thanks, Alex. Hi, everybody. I'm going to be going over religious accommodations for employees. And so the best place for us to start is Pickering and Garcetti. These are the leading Supreme Court cases on government employee speech. So critical to understanding both is the fact that the government, as an employer, has the right to speak to. In order to function effectively, the government needs to be able to convey messages. And one of the main ways it can do this is through its employees. One of the best ways to think about this was the government's response to COVID-19 and the way in which it spoke through Dr. Fauci. So this creates an interesting scenario when you talk about employees who are also being paid to speak, and then individually as private citizens have their own free speech rights. The government will need greater control in the employment setting, or it could never communicate a coherent message to the country and do what it needs to do. So Pickering is the early balancing test that the court fashioned, and it's pretty flowery, lofty language. It's typical of early balancing tests. It essentially requires balancing the interests of the public employee as a citizen in commenting on matters of public concern and the interests of the state as an employer in promoting the efficiency of public services it performs through said employees. And so then in Garcetti, the court kind of refined that test and moved Pickering to kind of like the third rung of it. So in Garcetti, the plaintiff was a prosecutor in Los Angeles, and he was concerned that a law enforcement official had lied in a search warrant affidavit and outlined his concerns in an internal memo to his boss. His boss told him to keep quiet, even though the prosecutor told him that he was legally obligated under Brady to inform the defense. The prosecutor ended up testifying for the defense later, and then he was demoted at his job. And when he sued for First Amendment retaliation, the Supreme Court said that the internal memo he gave to his supervisors was unprotected employee speech because it was made in the course of his ordinary job duties. So the holding of Garcetti is when employees make statements pursuant to their official duties, the employees are not speaking as public citizens for First Amendment purposes, and the Constitution does not insulate their communications from employer discipline. So in certain circumstances, public employees have less First Amendment protections than your average citizen. And so putting these two cases together, this is the framework for regulation of government employee speech. And that could be a teacher at a public school, all the way up to an LA County prosecutor. So a public employee's speech will be protected if it is on a matter of public concern, it is not made pursuant to their official duties, and the employee's First Amendment interests outweigh the government employer's interests in efficient administration. So that's where that little element of Pickering comes in. And one question that comes up a lot here is, what does it mean for speech to be on a matter of public concern? Also, what does it mean to be within an employee's official duties? The official duties is something that we're going to explore in subsequent slides, but the public concern issue, it's based like, if you want, I think about it as terms of like when you open up a newspaper, what's on the front page of a newspaper? Those are matters of public concern. How the court has defined it is when it can be fairly considered as relating to any matter of political, social, or other concern to the community. So scientific interests, literary interests, art, all of those kind of things would fall under a matter of public concern. So Kennedy v. Bremerton School District. This is a recent Supreme Court case. You may have heard of it. It's often described as a religious freedom case, and it is that, but it also has a free speech element, which is whether Garcetti, the framework that we just discussed, whether that applies. So Joseph Kennedy, he was a football coach at a public high school in Washington, and he's also a devout Christian. And he had a practice at the end of every football game. He would go to midfield and he would kneel and he would do a silent prayer, typically around 30 seconds, but they were in full view of spectators and players. Some players did join him. The school told Kennedy to avoid demonstrative religious activity when in view of students, but he did not, and he continued to pray, and he was placed on administrative leave. So he sued, And the Supreme Court held that the coach's prayers were not part of his official duties as a coach. And the school therefore violated his free speech rights by placing him on leave because of the prayers. And so this case is really interesting because it kind of takes two constitutional principles out of the First Amendment and places them on somewhat of a collision course. So as Alex mentioned, the free speech clause protects private religious speech. The Establishment Clause prohibits the government, which includes public schools, from conveying a preference for a particular religion. So what happens when a public employee is expressing his own private religious beliefs? And this is how the Supreme Court said it would shake out. In this case, he was not acting pursuant to his official duties, and so he had a right to pray. So in response to Kennedy, my mom was actually a former high school administrator in Missouri. And so when I was explaining Kennedy to her, she was a little bit surprised by the result. And I think that was somewhat of a widespread response to K-12 administrators and other personnel. And so the Department of Education released some guidance in response to Kennedy on how religious expression in schools is constitutional or not. And so according to this guidance, teachers, administrators, and other employees of a school cannot encourage or discourage private prayer or other religious activity among their students. But at the same time, the Constitution doesn't prohibit school employees from engaging in private prayer even during the workday, where they're not acting in their official capacities and their prayer doesn't result in the coercion of any students. So that's something that was kind of, it was a disputed fact in Kennedy whether or not students or players felt coerced to participate in the coach's prayer because they cared about how he thought of them, they wanted more playing time, things like that. So at the end of the day, the court felt that wasn't coercive, that didn't rise to the level of coercion. That's kind of where the line is drawn in terms of public employees being able to express their own religious beliefs in front of students. So based on all of those principles, we have a quick scenario followed by a poll. So we have a teacher who identifies as Catholic and works at a public high school. He keeps a photograph of the Pope on the wall in his office. And his office is a small room attached to his classroom. Other teachers also decorate their offices. They hang secular posters of their favorite bands, their favorite sports teams, their favorite artists on the walls. Students see the photographs when they visit the teacher for office hours, but otherwise they don't. So does the photo of the Pope in this public high school violate the Establishment Clause? And the poll responses are yes, no, or I don't know. So feel free to select a response and I'll wait until we have a bit of a critical mass and then we can discuss, we can kind of apply the principles we've already discussed to see whether this would be a constitutional violation or not. So it looks like we're having some trickle in. Okay, I'll go ahead and move forward. So most people say no, and about 85% of people said no. And I would say that's correct. So the question you would ask yourself here is there an element of coercion? Are there mandatory attempts to force students to be Catholic or to express agreement with the Pope's teachings? Or is this more of an expression of the teacher's own religious preferences in a setting where people would normally be expected to have their own personal effects that reflect their, the things that they like or dislike? So here it's more of the latter, plus it's the fact that the school allows teachers to have, posters of their favorite band or their favorite artist or sports team on the wall. It reinforces, those posters are unique to the teachers, and it reinforces that it's not official school speech. So we've covered Garcetti and the recent legal developments associated with that case. Now we have to wade into the issue of academic freedom, which is really interesting because it differs in K-12 versus higher ed. So academic freedom was originally understood as a professional norm in higher education that prioritized the protection of individual autonomy of the faculty members over institutional interference with their ability to conduct research. And that makes a lot of sense, right? Because a professor's speech, whether it's his writing or what he says in class or when he goes out and gives talks, that's the lifeblood of their work. But at the same time, the government is paying for that. But because of the unique nature of higher ed, professors are given a little bit more latitude relative to the institution to be able to speak in the way that they see fit. And Garcetti, as it turns out, it did not clarify how its holding applied to higher ed faculty members. They actually left that question open. It was raised by a dissent and basically sidestepped by the majority, so leaving it to the federal courts to decide. And in the wake of that, most federal courts have said that Garcetti does not apply to professor speech in the K-12 or in the higher ed context. But that's not the case in K-12. So professors at colleges and universities generally have more free speech rights than a teacher at a high school, a middle school, and elementary school. And the reason that this is because a lot of states for K-12 have mandatory curricular standards, and those in turn impose obligations on the school district where they need to have greater control over what their employees are saying. And in the higher ed, that's simply not the case, and so they have a little bit more flexibility. So Mirabelli v. Olson, this is one area where we're starting to see a lot of litigation in the First Amendment and Free Exercise Clause is the use of students' preferred pronouns. So we're seeing this both at K-12 and higher ed. This case is a recent case from a federal district court in California just a few months ago, and it's currently on appeal to the Ninth Circuit, so we don't know how it's ultimately going to turn out. But in this case, there was a K-12 district who adopted a policy that said teachers weren't allowed to disclose a student's gender identity, name, or preferred pronouns to their parents unless the child consents. And a group of teachers objected to that and said, hey, wait a minute, we don't agree. Like, we have sincere religious beliefs about being honest with parents and not being dishonest in our communications with anybody, but especially with parents. We think that it violates our belief to call a student one thing in class and to refer to them a different way with their parents. And so they sued, and they asserted two claims: a free speech right against compelled speech, and also that the policy burdened their free exercise of religion. So the trial court agreed with them. The trial court held that the policy was not generally applicable because it only applied to teachers and not other staff. And it also had certain secular exceptions, but it had no exceptions for religious objections. So the court applied strict scrutiny for those reasons. And that means that the district had to demonstrate a compelling interest or reason for this policy and show that it had also used the most narrow means to address the issue at hand. This is the hardest standard to overcome. The school responded saying that it had a general issue in protecting students from potential abuse or harassment from parents who may not affirm or may disagree with the student's gender identity. But the court said that that was too broadly formulated, and unless the school could point to specific students with specific parents or guardians who they had these concerns about, then that wouldn't justify this burden on the teacher's free exercise rights. So the district also claimed that it had an interest in the privacy of students, and the court said that just didn't stand up compared to the constitutional rights of the parents to for the care and upbringing of their children, that would outweigh the school's interest in protecting students' privacy from those parents. So in the end, the religious liberty claims prevailed, and the case is now on appeal to the Ninth Circuit. We'll see how the appellate court reviews the decision. We're getting an array of different decisions on this topic from many different courts. We'll discuss another one from the Seventh Court recently, but they're all coming out differently, and this issue we expect to make its way to the Supreme Court at some point in the future. So generally, this slide is going to provide the framework for the last two cases that we're going to discuss in this section. So what does an employer need to do to accommodate in a religious belief under Title VII? As Alex mentioned, under Title VII, employers, public and private, must accommodate an employee's sincerely held religious belief or practice unless the accommodation would impose an undue hardship, which courts generally define undue hardship as either a burden that is excessive or unjustifiable, or a substantial increase in business-related costs. So as you can imagine, very fact-intensive analysis. This depends on a lot of things, including the employee's religion, the specific practice or belief that's being burdened, the requested accommodation, the employee's role within the business itself, the industry standard, past practices, things like that. But this is the standard that is being applied now, which brings us to Cluj v. Brownsburg Community School District or Court. This is from a Seventh Circuit case. It's another preferred pronoun case. As we've discussed, schools often face kind of a double-edged sword when it comes to these cases. So on the one hand, you have religious employees who don't want to comply, and they may assert, free speech or religious expression claims. On the other hand, you have transgender students who feel they've been misgendered, and they may bring discrimination or harassment claims based on that staff member's refusal to refer to them by their preferred name or pronoun. And so this is obviously a very difficult situation. So in Cluj, the school district was sued by a former teacher who was Christian, and he refused to comply with the district's policy that required employees to call students by their preferred name and pronouns as entered in Power School. So unlike the previous case we talked about, Mirabelli v. Olson, this policy didn't prohibit the teacher from communicating honestly with the student's parents, because the only way the student could change their name or pronoun in Power School was with parent guardian approval and or a note from their treatment provider. And so Mr. Kluj's objection was based primarily on his religious belief that as a Christian, gender, male and female, is fixed. And so calling anybody by a pronoun other than the one that would be assigned to their sex at birth would violate his own religious beliefs. And so he started referring to students by last name only. School administrators were not amenable to that, and they said that he needed to comply with the policy, or he could resign, or he could be suspended pending termination, and he chose to resign. And then he sued the school, and he raised a host of claims ranging from violation of Title VII, the First Amendment, the 14th Amendment, state constitution, and state tort law. And so in Cluj, the school district's motion to dismiss was granted as opposed to the First Amendment claims, including the free exercise claim, the Fourth Amendment due process claims, the Title VII hostile work environment claim, the state constitutional claims, the IED claim, and the fraud claim. But then the district filed a motion for summary judgment on the two remaining claims, which were failure to accommodate his religious beliefs under Title VII and retaliation under Title VII. And the district court ruled for the school district, holding that the teacher's refusal to comply with that policy, even when he was referring to students by last names only, that was still an undue hardship for the school because it interfered with the school's ability to educate its students. It could make transgender students feel, and this is a quote from the court, targeted and dehumanized by Mr. Kluge, but it also subjected the school district to liability for Title IX from students who felt like they were discriminated against by the teacher's failure to use their pronouns. So then this went to the Seventh Circuit in April of this year, and they cited Supreme Court precedent, which said that the employer, in order to show an undue burden under Title VII, it need not bear more than a de minimis cost in making an accommodation for an employee's religious beliefs or practices. And so it agreed with the district court applying that standard. But then the Supreme Court established a new standard for an undue burden under Title VII, and that occurred in Groff v. DeJoy. And this is a 2023 case, and in light of that, the Supreme Court has vacated its ruling in Cluj. So Groff involved a Title VII claim brought against the United States Postal Service by a former employee. The employee's argument was that the USPS, by requiring him to work on Sundays, that violated his the USPS failed to accommodate his religious beliefs by asking him to work on Sundays, because that was a day that he felt was a day that he should, a day of rest, essentially, as a Christian. So the Supreme Court agreed with him. Not necessarily, they didn't directly rule on the case, they clarified the standard and remanded it. So the Supreme Court replaced the rule applied in Cluj, the de minimis cost rule, with a more stringent standard. And under this new standard, to overcome a Title VII accommodation claim, an employer would be required to show that the requested burden would result in substantial increased costs. So we're moving from de minimis to substantial in order to establish that undue burden. So after announcing the new standard, as I said, Groff was remanded. We're still awaiting further proceedings on that. Cluj is also currently on remand after the Seventh Circuit decision was vacated. And on November 3rd, Cluj filed a motion for summary judgment in the district court. So we're still waiting to see any response to that and then how the court bears that out. But with that concludes employee accommodation. And I'm going to pass it to Mary to talk about students.
Thanks, Claire. I just want to take one quick minute and thank Claire Tori and Alex and John from Husch Blackwell for putting this material together, doing such a fabulous job in putting this material together for our member districts. And I saw a few minutes ago a lot of names of general counsels and others from our member districts on today's webinar. So we're all very happy to see that, and we hope that this is a good use of your time. So with that, let's get started talking about religious accommodations for students. As Alex mentioned, we know that there are two basic principles that we look at when we talk about religion in schools, and one being free exercise and one being anti-establishment. And that's how the two principles are usually approached, even though the anti-establishment clause comes first in the Constitution. But nevertheless, the current Supreme Court, as we all know, has been sort of narrowing the anti-establishment clause more and more in recent years. So getting started with regard to religious expression by students. So we know that students must be permitted to express their religious beliefs subject to some rules, right? So students can organize prayer, they can organize school activities, initiate them on their own, and they can do so as long as they are not materially disrupting the educational program. They can read from religious materials, they can talk about religion in their homework, in their classwork, if the assignments lend themselves to open discussion or creativity or whatever the teacher might assign to them that would lend itself to them expressing and talking about their religion. Any allowances that are made for non-curricular student activity groups must be given the same treatment for religious activity groups. And so that's been the status of things for quite a long time. Students are permitted to use school resources for publications to the same extent that non-religious activities are allowed to use those same resources. So we can't discriminate in schools. We cannot discriminate against groups that engage in religious expression or target them or single them out. And so this comes from the Equal Access Act, which is located in 20 USC section 4071. And that statute is designed to ensure that religious activities are accorded the same access in federally funded secondary school facilities. Interestingly enough, that portion of the statute comes under a section of the US Code that really it deals with desegregation. So that was just sort of plopped in there. That section is plopped in there. 4071C is plopped in there, and it's, in my opinion, it's slightly an awkward placing for that, but I guess there was no other place within the education code to put that, the new statute when it was enacted at the time. Okay. Students can, like I said, express their beliefs with regard to homework, classwork. Schools must excuse students from class if it would burden their religious exercise to be in class or to be in school. And that includes things like fasting, praying, missing school, any legitimate religious activity that they need to engage in. Schools need to take into account the excuses for these things. This can't, obviously, there are some limitations, such as these activities can't impose a material burden on other students. However, if the activity doesn't impose a burden on other students, that it must be allowed. And as I think it was Claire said, schools can't encourage or discourage participation in these activities, right? You have to stay neutral, but where a school has the practice of excusing students for on a non-religious basis, then they need to be able to excuse them for religious purposes as well. So here's a scenario for you that I would ask you to answer in just a minute, but I'll read it out loud. So 20 students at a public school district in Texas are members of the Worldwide Church of God, which is a religious organization with over 68,000 members. Each year, the members must abstain from any secular activity on 7 annual holy days, as well as make an annual pilgrimage to a regional site for a 7-day religious convocation on the Feast of Tabernacles. As a result, the students have to miss 8 to 10 school days per year. Historically, administrators in this district had broad discretion to decide whether to excuse the absences. The students' absences in the past were always excused, but this year, the school district limited the unexcused religious absences to 2 days per school year. And under a new policy, the students could not receive credit for missed work due to unexcused absences. So in this scenario, does the school district's policy violate the students' right to free exercise of religion? Go ahead and take a minute to answer that question, if you would, please. Again, school district changed its policy and allows only 2 days for religious absences. Does this violate students' right to free exercise of religion? I'll just give it a minute. I see a lot of people are answering the question. We're at 42%. Okay, so we're over half now. 75% of those of you who answered said yes, the new policy violates the students' right to free exercise of religion, and 21% said no, and 3.6% said I don't know. The answer is yes. So the majority was correct. The students' right to exercise their religion was violated by the new policy. This is based on an actual case out of the Northern District of Texas in 1981, affirmed by the Fifth Circuit in 1982. Church of God, Worldwide Texas versus Amarillo Independent School District. And so again, as I told you before, previously the principals of the school had wide discretion to determine when an absence would be excused. And they were, in that case, instructed by the school to consider the choice of the student, which I guess the school district thought could get some principals into some trouble because it was just, there were really no standards. So when they revised the policy, allowing only 2 days, that was determined by the federal courts to be a violation. The court said that the policy burdened students' religious beliefs by penalizing them for their unexcused absences, and that the school district's argument that they had a compelling reason, which was regular attendance or avoiding administrative burdens on the schools, that was outweighed by the students' free exercise rights. Okay, so in the second principle that Alex mentioned earlier, we know that religious activity or expression cannot be compelled by the government, and that is still the case, even though, again, it's been narrowed in recent years. But under the Establishment Clause, the government cannot compel individuals to participate in religious activity. And to determine whether a school district or a state actor has coerced a student to participate in an exercise in violation of the First Amendment, the courts will look at whether the school has a captive audience, whether any religious activities were required for the students to partake in, and whether the students felt pressured to support the religious aspects of the activity when they saw others reflecting on the religiosity of the activity. So the Seventh Circuit held in 2018 in a case called Freedom from Religion Foundation, Inc. versus Concord Community Schools. The Supreme Court held that a Christmas program that was put on by the schools, that it passed constitutional muster, but it wasn't that simple at first. The first version of the show, upon which plaintiffs sued, was done for 45 years in this town in Indiana. I think it was Indiana. It was a Seventh Circuit case in, Indiana. For 45 years, the school put on a program where students sang religious songs and read passages from the New Testament. Student actors walked across the stage as if they were going to Bethlehem, and they posed and stood in front of a nativity scene for several minutes during the performance. Plaintiffs sued, and so the school district proposed first to revise the program to remove the spiritual readings from the Bible and to add some songs that would represent Hanukkah and Kwanzaa. Nevertheless, with that proposed version of the show, a preliminary injunction was still granted against the school. And then ultimately, what the school did was revise the show again. And the second time they revised it, they had approximately 5 minutes for each song explaining the holiday, for example, Hanukkah, Kwanzaa, Christmas. And during the explanations and songs, they would project images onto large screens accompanying the songs. And then for the majority of the minutes, however, they still performed numerous Christmas songs that were more religious in nature. And there was a nativity scene that appeared for about 2 minutes. So they still used the manger, but they also had mannequins instead of student actors, and there were no Testament readings in the ultimate revised version. And the court declared that version of the show was constitutional, and a permanent injunction was denied. So at that time, this is prior to Bremerton, the court applied the endorsement test and basically held that in the totality of the circumstances, a reasonable observer would not be offended or feel coerced to adopt or participate in any particular religion. The court dismissed the plaintiff's coercion argument in that case because they held that there was no religious activity in which the audience members had to partake. And the plaintiffs even argued that members of the audience seemed to be worshiping with the lights low. Even though the lights were low, they could see them worshiping, and that they were vigorously clapping during certain portions of the nativity scene and really emphasizing their cheers and their applause during the scenes related to Christianity. But the court said that you can't tell if they were just clapping because of your lawsuit and they were happy that the school won. They actually said that in the opinion, or if they were actually clapping because it was Christianity that was being highlighted. And so the plaintiffs raised several arguments. The court dismissed these arguments, saying that that the show was for educational and entertainment purposes and not for religious purposes. Okay, another scenario. So get ready, because I'm going to ask you another question in a minute. But in this scenario, a large public school district implemented a quiet time program whereby instructors who were certified in transcendental meditation would come into schools and teach the practice to interested students. The program was optional and the students could opt out. On the first day of the program, the students watched the instructor, who placed assorted items in front of the students and asked them to repeat certain Sanskrit phrases, which they later used as a mantra while meditating. The instructor returned every week for meditation sessions, which lasted about 15 minutes. And a student who willingly participated in the quiet time program later sued the district, arguing that the program violated the Establishment Clause because the meditation practice is based on the Hindu religion. So do you think that this quiet time practice violated the Establishment Clause? Yes, no, or you don't know? Waiting for your responses. Again, the question is whether the quiet time program violated the Establishment Clause. Got about 24% of people responding. Keep climbing. Yes, no, or you don't know. I can't see your answers. We won't hold it against you. Okay, so we've got 61% of people responded, and 69% of that 61% say that the program did not violate the Establishment Clause. Very interesting. 24% think that it did, and 6% say they don't know. The answer is possibly, but we won't know because the parties reached a settlement on September 22nd, 2023. This is based on a case, Williams versus the Board of Education of the City of Chicago. The district court denied both parties' motions for summary judgment, holding that there were genuine issues of fact as to whether the students were actually a captive audience, whether the program is in fact religious in nature. But if you do a little digging, you will find that that type of meditation is rooted in Hindu beliefs, but it predates Hindu religion. So that would be an interesting question of fact to see the evidence and what the parties brought with that. And then there was also a question of fact as to why the students, whether the students were required to participate in the program. So this case was brought against the Chicago schools by the organizations called the Separation of Hinduism from Our Schools and the Civil Liberties for Urban Believers group, and then some individual plaintiffs. And like I said, the parties settled in September. Okay, as for student attire and dress codes, we all know that many school districts have them, and they are obviously allowable, but they cannot target religious attire in general or the attire of any particular religion. So if you make any exceptions to the dress code for any non-religious student needs, then you must also make comparable exceptions for religious needs. And generally speaking, students may display religious messages on their clothing, backpacks, and so on, to the same degree that they may display non-religious messages. So you can adopt or revise your policies relating to dress code and uniforms to the extent that's constitutional and permissible. Again, you can't target any particular religion, and you can't hold religion to a different standard than non-religious expression. You may have heard of this case. This case was memorable because this was for a couple of reasons, but this is a case that was decided just recently. I think it was earlier this year, this summer. This is Charter Day School versus Peltier. This is a public charter school that required female students to wear skirts to school based on their view that the girls are, quote, fragile vessels deserving of gentle treatment by boys. So obviously they were asking for a lawsuit. The plaintiffs brought suit arguing that this was obviously a sex-based classification grounded on gender stereotypes in violation of equal protection and Title IX. And also the charter schools argued that they maintained that they were not a state actor, and so that the equal protection analysis should not be applied to them. I don't know if they had the same argument for Title IX because obviously they would have been a recipient of federal funds. So in this case, a gentleman named Baker Mitchell is the founder of Charter Day School. He as far as I know, he was a corporate executive from Texas who ultimately retired and moved. He sold his company in Texas, became like a multimillionaire, moved to North Carolina, and decided that he wanted to set up a charter school. On his company's, on his nonprofit website, he gives a little bit of his backstory, and he said that when he lived and worked in Texas, he went into a public school as like a guest speaker for the day, and he was so impressed with the principal and the student achievement in a low-income area that he wanted to, his dream then became to start a charter school. So he started a charter school, and he is now currently a non-voting member of the board of the charter school. He's the board secretary. And he's also the founder and president and shareholder of the charter school management company, of course, that runs the school, called Roger Bacon Academy. So I raised this for a reason that I'll tell you in just a minute. But the court did hold that the charter school was a state actor for purposes of this Title IX and equal protection analysis. And it was interesting, though, because the charter school was held to be, but the management company was dismissed from the lawsuit, was held not to be a state actor. And it was very interesting because the defendants, the court says at one point that the, I'm sorry, it wasn't I didn't mean the court. In discovery, the attorneys for the charter school said at one point that the corporate defendants, plural, are responsible for controlling the schools, the teachers, and the administrative personnel. They were all part of, controlled by the corporate defendants. And so when the court dismissed the management company, they held that, it was the nonprofit charter board that runs the school, not the management company. So they're a private actor and not a state actor, and therefore they would be dismissed. It's just food for thought. I know some of you deal with that in your practice, in your daily practice. Nevertheless, the court held ultimately that the charter school violated both the Equal Protection Clause, obviously based on sexual stereotypes, and also violated Title IX. The district court did not held that Title IX was not violated because, in the district court's opinion, Congress left it up to, the Department of Education, because this question was not explicit in the statute. And so the district court held that the Department of Education allowed issues of dress code to be handled at the local level. But the Fourth Circuit reversed, saying that had Congress or the Department of Ed wanted dress code to be excluded from the analysis, they would have included it with many other exclusions from Title IX. Okay, so the Fourth Circuit, again, affirmed the district court's entry of summary judgment in favor of the plaintiffs and remanded. The court, again, held that only the charter school was a state actor for purposes of equal protection, and that the skirt requirement was blatant gender stereotypes. Another interesting part about this case is that the first attorneys for the defendant corporations, being the nonprofit charter school board and the management company, before they were dismissed, the attorneys actually were sanctioned in this case because they wanted to send an expert into the classroom to observe the students' behavior, to try to refute the plaintiff's claims that the girls were hindered in any way in their education by having to wear a skirt. The plaintiffs had argued that they don't have as much freedom of movement, that they're worried about crossing their legs and how they're sitting, and therefore they are being treated differently than the boys because the boys can run and jump and play outside and the girls cannot do so. So the defendants' attorney said, okay, well, we're going to send our experts in to observe their behavior. And the court held in an evidentiary hearing, in a discovery hearing, that they were not permitted to do mental evaluations, that the students' mental state were not at issue in the case. And what they did, at the behest of the management company owner and founder of the charter schools, they put cameras. They had cameras in the classroom. And so they had experts do expert observations via cameras in the classroom. And they were sanctioned by the court and removed as defendants' counsel subsequently because the court had already ruled that that would not be permissible. There's just some interesting tidbits about that case. All right, the Supreme Court denied cert in this case, which was a good sign. June 26, 2023, the Supreme Court denied cert. All right, and one other last point is that under Title VI, shared ancestry and ethnic characteristics falls under national origin or ethnic discrimination. And so you should be careful that your principals and your administrators are aware that any perceived ancestry or ethnic characteristics are covered under Title VI. And this includes a country of origin, a dominant religion, or a distinct religious identity. Just this month, November 7th, 2023, a Dear Colleague letter was issued by OCR reinforcing that shared ancestry and ethnic characteristics fall under the laws that protect the laws that protect people from national origin or ethnic discrimination. And that is all that I have. Turn it back to John for closing.
Thank you very much, Mary. We've gone a little bit over, so just send your questions in and we'll respond via email. I want to put in a little plug for our K-12 Legal Insights blog. We're really going to be posting a lot next year. For those of you who are already on, we haven't been posting much, but we're doubling down next year. Thank you all for joining us today. We hope that this information was helpful to you and your organization. I've got 3 quick reminders. The program has been approved for continuing legal education credit. To report your hours, click on the CEU icon at the bottom of your screen. Secondly, a certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing within your organization. Finally, please be sure to complete our short survey. We use your feedback to plan future programs that we hope will be useful to you in your district. Thanks again for joining us. On behalf of Mary and the council and my colleagues, I'd like to wish you and your families a very happy Thanksgiving and a happy holiday season. We'll be back with another program for you in January, and that concludes our webinar today.